Decided on May 1st, 2019, Lee and Superior Wood Proprietary Limited involved a decision by the Fair Work Commission that the appellant, Mr. Lee, had been unfairly dismissed from his employment because he did not comply with an employer policy which would have required him to submit fingerprint scanning to sign on and off for work. In this episode, we'll look at some of the data law aspects of this decision.
Definitely, yes, there are a few. Firstly, the scope of the concept of sensitive information under the Privacy Act. Secondly, the scope of the employee records exception. Thirdly, how transparent one needs to be when collecting biometric data. And fourthly, whether an employee or anyone else that matter can claim property rights in their personal information. Sensitive personal information included the fingerprint information that Mr. Lee objected to. The key point is that information collectors who are bound by the Privacy Act really need to get their head around the types of information they're collecting and to know that the compliance measures are much higher when you're dealing with sensitive information such as biometric information. The key finding from this case is that the employee records exemption is quite narrow. It does not apply to information yet to be collected by the employer. It only relates to existing information held, and it needs to relate to the specific relationship with the employee, not to all employees generally. The Commission looked at what Mr. Lee had been told in response to his questioning about who was going to hold the information, where it was going to go and what was going to be used for, and agreed with him that it was inadequate. It's a good lesson for transparency requirements in Privacy Act compliance. No, Mr. Lee succeeded on employment law grounds. He did not succeed on the basis of his claim that he owned his data.